Well, that decision by the High Court today significant when it comes to Fortescue and, more importantly, perhaps also founder of the company, Andrew Forrest, the right now to return as non-executive director, not breaching the court holding continuous disclosure obligations. What are the more broad implications of this, though? Well, Sally Scott is partner in Helen Wilcox's Commercial Dispute Resolution Group and now joins us from Melbourne. Nice to have you company. Thank you so much for joining us. Just looking at a fairly brief statement from the bench, what was, I suppose, for you the most significant point from that?
Well, interestingly, this case really could have had a significant impact on Forrest. He could have been banned from running his company, he could have been banned from being a director, and in fact having any senior management role in both Fortescue and in fact any company. So this is a really significant decision for Forrest himself, for the investors, and also for the legal community in relation to obligations concerning continuous disclosure to the market and also misleading and deceptive conduct allegations in relation to statements to the market.
That's the thing, Sally, in that last response from you, that there were kind of 2 points of dispute, were there not, at least from where Fortescue sat, based on that federal court decision, which originally cleared ASIC to find Fortescue had erred. First off, let's look at that misleading or deceptive conduct. You know, what did it really come down to from where the court sat?
Well, the court looked at the statement itself and looked at what the representations were to the investors, to the market. The ASIC position was that the statement represented that the contracts were binding, that they were legally enforceable. The High Court held a different position. In its view, the High Court held that the statements represented to the investors that they were not legally enforceable in the courts, these contracts, but just that the contracts had been intended by the parties to be binding. So it's just that fine distinction as between what the intention was and whether or not the statements went so far as to represent they were legally binding in the courts.
ASIC then went the next step and was arguing that Fortescue had a continuous disclosure obligation and it breached that, it contravened it, and certainly that was a key possible development in directors' duties at stake. How were they arguing that had occurred?
The misleading, or the allegedly misleading statements were made during the period from August 04 to February-March 05. There were numerous statements, both statements made to the ASX under the continuous disclosure obligations, and there are also statements made to via press releases and in briefings to investors. The interesting point was that the market had, the High Court was looking at whether or not those statements were misleading, whether or not after the original statements were made and Fortescue and Forrest determined and realised there were some problems with these agreements. They weren't binding, they weren't, they were in fact conditional. ASIC alleged that at that point, at the moment they realised, at the moment Forrest and Fortescue realised that the agreements were no longer binding, that under the continuous disclosure obligations, Fortescue and Forrest were bound to inform the market and correct the previous position. So ASIC asserted that they breached those continuous disclosure obligations by failing to correct the position.
Everything so often turns on the specific facts of any given case. Therefore, because of the unique nature of what did go on, as you've essentially outlined, what are the wider implications, particularly on that latter point you just made?
Well, there certainly would have been further implications and a more worrying position had the court come down the other way. even though the court has said that Forrest and Fortescue are not responsible, they're not liable, they didn't make the representations that were alleged by ASIC, it's still a really important case just to demonstrate how far a case like this can come. The parties have been in dispute for over 8 years. The case was involved transactions back in 2004 and statements back in 2004. And it's been estimated that parties have incurred expenses of in excess of tens of millions of dollars. So even though the High Court didn't go so far as to say that these particular statements were misleading, directors and officers really need to take care as to whether or not their particular statements are misleading, because they might not be able to get off in the same way that Fortescue did. It's quite a fine point as to how they got off. So it may be inferred that the courts will be lighter, and ASIC may, as a result, be lighter on companies and directors in this situation, but it can't be assumed. You don't want to get involved in a court case and be facing these sorts of legal costs, and you don't want the damage to the reputation either.
What's interesting is almost a return, it seems, strains of deja vu over the hypothetical that ASIC tends to run, or at least has formed for running, in cases like this. One thinks of the Metcash, Coles, Woolworths backdrop of a hypothetical competitor being denied entry into the market. Here, another argument about should a dispute ever arise between two parties. Again, looking into the future, Sally, and trying to persuade the court of events beyond the here and now. Is that, in your view, an approach that has come back once to bite ASIC, and if not learning from it once and now twice, there's something seriously wrong with the way it's running these cases?
I wouldn't say that there's a big problem for ASIC in this case. Keep in mind that although the High Court decision was unanimous, only months ago the full federal court unanimously held in favour of ASIC. So it's not as if you can say that ASIC is going down the wrong path. It made a decision that three very senior federal court judges all unanimously held in favour of.
Well, is the federal court going down the wrong path if the highest court in the land deems it was wrong?
Well, it's a fine point in this particular case. I can certainly see and understand ASIC's position, and you can also understand the position taken by Forrest and Fortescue and the High Court. It's not a clear decision. You couldn't predict with any great accuracy which way the court would go, and as I said, the full federal court went in the opposite direction. I wouldn't say that the federal court is lacking in any ability. They have some brilliant judges in the federal court. It's just a very fine legal point, and therefore directors need to ensure they don't take too much comfort from this decision. It was a fine point. They still need to take great care with, firstly, every announcement they make to the ASX, to the market and to the public and to investors, and they also need to ensure that they take great care that if they do realise that a previous statement is incorrect, that they correct it, and therefore that they comply with their continuous disclosure obligations.
Well, no doubt the Australian Securities Exchange, which is planning to release a new policy guideline, will make that crystal clear. One hopes it will.
That's right.
Sally Scott Palmer in Hall & Wilcox's Commercial Dispute Resolution Group. Thank you so much.
Thank you.
Appreciate it.